Thank you for joining us in this webinar on the Danish Public Housing Law case, which, as some of you, maybe all of you will know, has attracted so much interest since it was first sent to the court in Luxembourg. I hope that you can all hear me, but if you do have any technical issues during the webinar, please do send a message. And my colleague Damien Chen, who is providing us with technical support, will try to sort it out for you. So let me introduce myself. My name is Iyiola Solanke, and I'm a professor in European law at the University of Oxford. And I'm also the director of the Institute of European and Comparative Law at the University of Oxford. And my role this evening is to act as moderator alongside Professor Sasha Garben. Give everybody a wave, Sasha, who is a professor in EU law at the College of Europe. She's also an official at the European Commission, a legal officer, currently on leave to be at the College of Europe full time. And beyond that, she is a replacement judge at the Amsterdam Court of Appeal. She also works alongside Professor Panos Koutrakos as the co-editor of the European Law Review. And in addition to his editorial duties, Professor Koutrakos is Professor of European Union Law at City University, as well as a door tenant at Monkton Chambers in London. So it's interesting, the IECL, the College of Europe, and the European Law Review, we've organised this webinar together. We all marked important milestones in 2025. It was 30 years since the establishment of the IECL, 40 years since the establishment of the European Law Review, and 75 years of the College of Europe. Here at the ICL, we are planning a series of events, including additional webinars throughout 2026, as well as a conference on assimilated EU law in April and on comparative regional law in September. But today, the IECL and the European Law Review are delighted to bring together in discussion junior and senior academics, including Professor Tamara Ćapeta, the Advocate General in this case on the Danish Public Housing Law. We're very grateful to all of them for agreeing to speak at this event. And it's just occurred to me that I didn't ask Panos to give a wave to the audience. So Panos, if you could just quickly let everybody know who you are. Thank you. We are very grateful to our speakers for agreeing to join us at this event. And as you will hear, they all bring different perspectives covering just some of the methods that we use in the study of EU law: doctrinal, decolonial, national, and the institutional. I'll introduce them all now. And then once I finish speaking, we'll go straight into the presentations, one after the other. So first of all, we're very lucky to have with us Professor Ćapeta. She will be the first speaker, and she will provide us with an outline of the case and the core questions sent by the Danish court. What is the scope of ethnic origin in EU law? In addressing this question, we get a sense, I think, of the limits of protection from race discrimination in EU law and the role of the CJEU in protecting and promoting EU values such as non-discrimination. So Professor Ćapeta has served as an Advocate General at the court since October 2021. She was previously a Professor of EU Law at the University of Zagreb, where she co-founded the Department of European Public Law and led several major academic initiatives. And her research focuses on judicial legitimacy and the constitutional dimensions of European Union law. Tamara, perhaps you could give everybody a quick wave. Thank you. Professor Ćapeta will be followed by Nozizwe Dube, a more junior, and I think most of us who hear her speak would agree, a rapidly rising academic who will help us to understand and think about the questions raised in the case from a critical perspective, highlighting in particular what we can learn about the concept of race in the Race Equality Directive and in EU values. Nozizwe is at the moment a doctoral candidate in EU law at Maastricht University within the Department of International Law. Her research offers a critical race feminist analysis of the EU equality framework, with a focus on intersectional discrimination and the role of decoloniality in European legal structures. And in 2023, she was selected as one of the 12 Faces of Science by the Royal Netherlands Academy of Arts and Sciences. Nozizwe, if you could just give everybody a quick wave. Thank you. We are also fortunate to have with us Hanna Eklund, who will help us to appreciate the case from the national perspective. I think it's noteworthy that this case was sent from Denmark rather than a country with a larger number of Black and minority ethnic citizens. Or maybe that's precisely why this case emerged in Denmark, as it is relatively new in its experience of these issues and is only slowly coming to terms with its status as a multiracial and multicultural society. According to Statistics Denmark, 11% of Denmark's 5.8 million inhabitants are of a foreign origin, and 58% of that 11%, so over half of them, are from a country that's considered non-Western. And this is, of course, a category at issue in the case, and it covers all countries in Africa, all countries in South and Central America, Asia, and Oceania, other than Australia and New Zealand. Hanna Eklund, Dr. Hanna Eklund, is currently an assistant professor of constitutional law at the University of Copenhagen, and she holds a PhD in European law from the European University Institute and is the principal investigator of a research project on colonialism and EU law, writing legal histories for the future. Her research also focuses on EU law, constitutionalism, and the relationship between law and social change. And finally, we will hear from Professor Bruno de Witte, who many of us know and cherish as a founding figure in the field of EU law. He will put this case into a broad institutional perspective for us. So from his purview of experience, he's well placed to set out for us what we can learn from this case about the CJEU as an institution and its self-vision of its institutional role as a body mandated by the treaty to serve the peoples of Europe. Bruno is currently Emeritus Professor of European Union Law at Maastricht University and a part-time professor at the European University Institute. He is indeed a leading scholar of European constitutional law, and his work also covers the relationship between European, national, and international legal orders and the protection of fundamental rights and cultural and linguistic diversity of Europe. So that's our speakers. We have 90 minutes in total for the webinar, and I have asked each of the presenters to speak for around 15 minutes, which should leave us with 30 minutes for a Q&A. As I said, please do use the Q&A function in the webinar to submit your questions as they arise in your mind. Sadly, we won't have time to answer all of them, but we will do our best. So now, without further ado, I will hand over to Professor Ćapeta. Tamara, the digital floor is yours. Thank you.
Thank you very much, Iyiola. Thank you very much for inviting me for this actually very expeditious webinar, because it was just maybe a few days for us that the judgment was published, because in the meantime we had the winter break here at the court. So it is a completely fresh judgment. So it is very, very timely seminar, probably the first one that was organized on the topic of this judgment. So thank you, and thank you for inviting me. I had the pleasure, as you know, to be an advocate general in that case. So I'm pretty much familiar about how the case came to the court and what is in the behinds of that case. And what is my intention here is just very quickly to introduce you to the case, because I actually don't know exactly who our audience is, but probably you are not that much in the case, even though you know the basics. And I'm going to say just a few words then about what the issues were, how I dealt with them, and what the Court of Justice did in its judgment. So the case came to the Court of Justice as a preliminary reference, which is important in terms of some criticism that were published immediately after the judgment about the court's judgments, and I'm going to come back to. So it is a preliminary reference from a High Court of Eastern Denmark, Østre Landsret, which is two of the high Danish courts, and that court merged several cases that were pending before it, all of them about the same issue. The cases, I can group them into two groups. One group are the cases that came from the city of Slagelse in Denmark, in which a number of tenants was the leases of the number of tenants who lived in the public housing units was terminated, and they opposed this termination of leases, and the housing organization initiated the procedure before that court, asking the court to declare this termination of leases lawful. And four of the cases came in this way to the Danish court. One case was from a different place in Denmark. It was in the city of Copenhagen, in an area called Mjølnerparken. And the case came to that court by an action introduced by a number of tenants of that residential area, Mjølnerparken, in which they asked for the declaratory judgment that the ministry's the ministry's decision that this area has to be emptied, so to say, through a development plan, and I'm going to come to why this has happened, is unlawful. So they asked that a declaratory judgment that this ministry's approval was unlawful. Both cases started in Denmark already in 2020, so we are 5 years from the beginning of those cases, and we are not yet done, because after the judgment of my court, there is still the Danish court that has to decide the case. So the story is going on for some time. So what's the cause of the story? The cause of the story is Danish law on housing that was adopted already in 2010, but was amended in 2018, and I will start from there. That law provided for the description of several types of, let's say, problematic residential areas that exist in Denmark. Some of those areas are named vulnerable residential areas, and vulnerable residential areas are those who have 2 of the 4 characteristics that are seen as problematic, either low employment, so tenants, residents who are over a certain average unemployed, high crime rates, low education, or low income. So 2 of the 2 criteria place the residential area into the group of vulnerable residential area. And then if such a vulnerable residential area on top of those characteristics is also inhabited by more than 50% of something that the law calls immigrants or their descendants from non-Western countries, then this law is called today parallel society, and that area is called parallel society. Previously, it was called ghetto. And in this case, provided that the unfavorable circumstances exist for 5 years at least, Danish law on public housing imposed an obligation on the one hand, public housing organizations. So those organizations that take care of the lodgings in which these people live, and the local authorities together to draft, adopt, and implement then something called development plans. And the most important goal of these development plans is to lower to 30%, to not more than 40%, sorry, the public housing units in this kind of area. Then these kind of areas are called then transformation areas, and in the previous version of law, they were called hard ghettos. So because of this law, in these 2 residential areas that I told you about, so one in Slagelse, the other one in Copenhagen, the development plans were developed. Mostly the idea was to sell to the private developers, private investors, part of these apartments. And to do that, it was necessary to lodge out the tenants from their apartments. And this is what caused the cases. The main claim of the applicants, well, actually they were defendants in one of the cases, in the Slagers cases, but doesn't matter. The main claim that they had was that the Danish law on housing requiring the adoption of such development plans is discriminatory and contrary to their fundamental rights, among others, the right to home. So these two issues were raised before the national courts, and the claim that we related to the discrimination on the grounds of ethnic origin then reached the Court of Justice. At the Court of Justice, the case was received in 2023. Hearing was held in September 2024. Then I published my opinion in February 2025. And as I said, just before the end of the last year, there was a judgment of the Court of Justice. Now, and I'm going to try to be very short because I know that we don't have a lot of time. There were two questions that were asked in preliminary reference. And you know that the preliminary reference, that for the audience, if not all of you are from the area of EU law, preliminary reference is a procedure in which national court can ask the Court of Justice for the interpretation of the European Union law, the part of the European Union law that is applicable, that is relevant for resolving the case that is pending before the national court. So what the Östgelandret asked the Court of Justice were two questions. The first question was whether the law, Danish Public Housing Law, is constructed, including this division to non-Western and Western immigrants and their descendants, can be characterized as ethnic discriminations, or actually whether this kind of division can be seen as the division on the basis of ethnic origin. That was the first question. The second question was then whether, if it is, we are faced with a situation of direct or indirect discrimination. So this is how the questions came to the court. Two questions. First question, what is ethnic origin? Second question, whether this is direct or indirect discrimination. Now, these notions of ethnic origin and of discrimination on that ground are the notions that exist within one of the equality directives that exist in EU law, Directive 2043, which I admit I called in my opinion, and I apologize to Iyiola, and I accept your criticism. I called it a Race and Ethnic Origin Directive, omitting in my shortened title the name equality. But yes, this is one of the package of directives that was adopted in the European Union to fight, let's say, for the establishment of the equality on certain grounds within the European Union legal order. So this directive is only limited to the two grounds of discrimination, race and ethnic origin. So the question of the national court, the first one was whether what the way in which the Danish law was drafted could be seen as ethnic discrimination. So discrimination on the ethnic grounds. And I have to admit to you that for me, this first question in the case was most difficult. It was most difficult to find whether this kind of discrimination is indeed the discrimination on ethnic ground. It was obvious that there is some kind of differentiation that exists in this case. However, whether the division of people to those coming from West and those coming from non-Western countries is the division on the ethnic criterion or something like the bigger civilizational criterion or whatever else was not that obvious. So I spend, in my opinion, most or a lot of the time trying to find whether this is really ethnic discrimination, and my conclusion was that it is. However, it was not easy to conclude that this was ethnic discrimination, that it was ethnic criterion, so to say, because the definitions that you can find about what is ethnic origin usually group people on the basis of some common criteria, be they common culture, religion, language, nationality as well. So language, I did say already language. So different common features. However, the problem was that the people who belonged to the non-Western group under the Danish law belonged really to the majority of the world. They were, as the Denmark was claiming at the hearing, covering 90% of the world. So they obviously didn't have really common ethnic characteristics in the usual sense how we would think about. So it was not that easy to find that this is really ethnic discrimination on the basis of ethnic criterion. So the way how I came out with it was to find that actually what grouped those people was that not that they belonged in some group according to the common criteria, but rather that they did not belong to another group which was perceived to have common criteria. I try to explain in the opinion that my understanding of ethnic criterion or ethnic origin is, or ethnicity, is in perception, in social perception of whether there is a people who are for some reason perceived as a common group, as one group. And obviously non-Westerners could not be perceived as one group unless you juxtapose them to the Western group. And the Western group, as you explained at the beginning, was the group of countries that were, and this was taken from the statistical office in Denmark, was the group of countries that were predominantly white, Christian in culture at least, and I would say also English speaking in the sense that most people in those countries speak English, even though they are not, this is not their language. In any case, there was a perception that those countries, in a way, represent culturally closer groups, perception of the Danish legislature. And that's why the rest of the world was put in a different group. However, the criterion on the basis of which this was done were the criteria that are usually used to describe ethnic groups. There is no one and easy way how to say what is ethnic. I have placed in this description everything physical and socio-cultural characteristics that could put people in one group, which it may be that I put together race and ethnic origin. However, in my view, this directive precisely wants to prevent this kind of divisions, which are the divisions to us and them. So in short, and we can discuss about that later, and I'm certain that there are going to be that many of the participants here will have to say a lot precisely about this part of my opinion and later on of judgment. I found on the basis of this that this is an ethnic criterion. Now the question was if this is an ethnic criterion. The second question of the court was whether this is then direct or indirect discrimination. And obviously for the discrimination, there has to be the adverse treatment of a person or a group of persons. So I had to first think whether there is any adverse treatment. And if there were adverse treatment, which is based on that criterion, which I found to be ethnic, it was very obvious to me that then, in that case, we are faced with direct discrimination, because direct discrimination is precisely defined in that way as the law, the rule, or the behavior which treats one person or a group of persons less good, adversely, bad, precisely because that person has this kind of criteria, which we can say are ethnic. So on the basis of ethnic criterion. So if this is ethnic criterion, obviously this kind of discrimination is going to be direct discrimination, provided that it places people who belong to that group, or on the basis of that criterion, better to say, in an adverse position. And then I found that there are two ways how we can say that these people are adversely treated, or treated, as the directive says, less favorably than the other group. And these two situations were, first one, which was relatively clear and relatively, how would I say, the classic way how we think about direct discrimination is to look to the comparator and then see whether the people who are, when we compare the two groups, people who are in the first group are treated worse than the people who are in the group that is comparator. And it's here, and I explained that there are areas that are also in bad shape, so to say, because there is crime in those areas. There are people who are not very educated, they have low incomes, and they are largely unemployed. However, in those groups of people, there was no any obligation to expel those people from their public housing units, just because less than 50% of people living in those areas were perceived as Westerners. So obviously the criterion, and because of this, obviously there was a larger chance, because it was not a certainty, but there was a chance that the people living in the area described by the ethnic criterion would be adversely treated, as they are going to be, they could be deprived of their houses. So I found that this would be direct discrimination. However, the case was more complicated, because what was challenged before the national court was actually the implementing measures of that law. So it was the measures that were adopted by the local administration and the housing organizations in order to put in place those laws. And these development plans that were adopted did not provide that the people who are going to lose their apartments are people who are non-Western, let me call them like this now, not to use the entire sentence. So that was not the criterion that was used to decide who is going to be, whose lease is going to be rescinded. Rather, the criteria were, let's say, neutral in terms of ethnic origin. The criteria were, in Slagelse, it was low income and crime rate, crime record of the persons. In Copenhagen, in Mjølnerparken, there was no criteria, because actually the entire 2 blocks were sold. You can also wonder why there was this difference. Well, I have to tell you that I have learned that the area that was sold in Copenhagen is a very attractive market-wise area, because this is an area that is becoming very hip area, and the private investors would probably have a good return on their investment. On the other hand, the Slagelse situation is not comparable to this. Okay, so I have, as I said, so I found that this is direct discrimination, because on the basis of the classical methodology how to find this direct discrimination, there was a comparator, and comparator was in a better off situation than the discriminated group. However, I also found that the other reason why we should consider this to be direct discrimination was the fact that this group was actually stigmatized. So I try to say that stigmatization, understood for me, and I'm going to tell you how I understood stigmatization, because it is not easy, and Iyiola, of course, wrote the entire book about it, so she would know much more than me about it, but I needed some kind of working definition for me, and I'm trying to find it now. I'm sorry. So I kind of understood stigmatization for my purposes as a situation in which members of an ethnic group are attributed socially reproachable characteristics solely on the basis of their membership or perceived membership of that group. So obviously, this kind of stigmatization, if it is connected with the bad characteristics that are attached to the group, can in itself place people belonging to that group in a precarious position in a society. And therefore, given that I understood the European Union law and European Union's law in behavior in how equality is understood as an effort to eliminate structural inequality as well, this kind of discrimination, therefore, is something that obviously the directive of this kind wants to eradicate, and therefore should be placed into the group of direct discrimination. However, as I said, the case was less easy because the criterion on the basis of which the people who will lose the apartments were chosen was not directly the criterion based on ethnic origin, but some more neutral criterion. And the directive has another category of discrimination that is called indirect discrimination, which says that it exists if on the basis of a rule that is neutral, nevertheless, by the application of this rule, certain person or certain group who belongs because of the ethnic criterion is more adversely targeted or affected, to say. So the Commission actually tried and I don't know yet why, I never understood why, but Commission was there very eager at the hearing to say that the discrimination in this case is not direct discrimination because we are faced with a neutral rule, because the choice was not based on the ethnic criterion. So what I offered as the alternative to the court is how to deal with this type of situation. If the court really would treat this situation as, or this rule as a neutral rule, how to find that whether this is discrimination or not. The difference is that direct discrimination, according to the directive, in principle, cannot be or can difficultly be justified, whereas indirect discrimination could. And the question that arose in that respect was what the Denmark is offering as justification. And what was on the table was the effort to enhance, to help in integration on non-Westerners into the Danish society. Now, there was a lot that was written about that, and I'm not going to say much more about it because I've seen that my time is coming to the end. I'm just going to say, so what I propose to the court shortly is, this is ethnic criterion that the law is using. It is direct discrimination because this ethnic criterion is the direct reason why people in those neighborhoods are treated more adversely than people in other neighborhoods and are, by the way, the same law stigmatized. And if by the chance the court finds it as indirect discrimination, it is most likely not justified. But of course, I left it to the national court because I didn't find completely that effort to integrate those people is passing the proportionality test already on the first level of being appropriate for that purpose. Now, the court passed the judgment, as you know, just before the new year. And there was a lot of, well, the first blogs and first reactions were quite critical. But the most important reason of criticism was that the court left everything to the national court. Now, what I want to say here is that this is the normal thing in preliminary ruling procedure. So it is always for the national court to choose. And it is true that the court can be more or less clear in giving the instructions to the national court. in my reading of the judgment, and I can admit that it is not very easy to read the judgment, which always is the sign that it was not easy for the 15 judges to decide on how to go with this situation, which obviously is not an easy situation. And what maybe I forgot to say is that this case never asked the Court of Justice either to say whether Denmark can regulate public housing or whether they regulate it rightly or wrongly, or how at all Denmark should resolve the problems that exist. The only question before the court was whether this is ethnic discrimination, and then whether it is direct or indirect discrimination. I would say that the court more or less clearly stated that this is a discrimination and that this was the ethnic criterion, left it for some reason to the national court to find whether it is direct or indirect, but gave quite a lot of instructions to the national court to be able to let's say, nudge it to find discrimination. So I'm going to finish here. I'm very willing to answer any questions, but I'm actually even more eager to hear what the others have to say about the judgment.
Thank you so much. We didn't give you very much time to summarize such a complicated case. Sorry about that interference there. Thank you so much. We didn't give you very much time to summarize such a complicated case, but I think it's been so helpful to hear you set out what the issues were. For example, that it was the termination of the leases that were being appealed before the Danish court, and that it was an Article 267 reference. So without any further ado, I'm going to hand over to Nozizwe Dube, who I think has some slides to share. So if you want to share your screen, and then we can, yes, listen to your presentation. It's a bit small at the moment. I don't know if, yeah, that's it. Perfect. Yeah.
Okay. I hope you can all hear me.
Yes.
Yes. Okay, great. I wanted to take this opportunity to first just thank the organizers for organizing this, but also for asking me to include my own observations of this case. As Professor Solanke already mentioned in the beginning when she was introducing me, in my own doctoral research, I conduct a critical race feminist analysis of EU law, and this is what I'm essentially also trying to do in my reading of this judgment. Without further ado, all right. Without further ado, this is what I'll be discussing over the next couple of minutes. I'll start off by trying to place this case in its broader context, so trying to place it a little bit outside of Denmark as well to show the case's relevance, in my view, for the European Union at large. Then I'll go over to discuss why I think that race and racialization could have been useful concepts for the court to explore in its analysis of the discrimination at hand in the Danish law of public housing case. Then I'll go to the second leg of my argument, where I'm discussing what I think to be at least some problematic, maybe some concerning allegations that are kind of being made by the court towards the end of its judgment, which I think kind of are related to problems that arise when the court relies on comparators. And then I will then conclude with a summary of my two arguments. So by way of introduction, I think we can clearly see, of course, that the concept of non-Western origin is obviously quite central to the case here. And I think that this concept is really a reinvigoration of historical concepts that have also been used throughout history to racialize marginalized communities, not just in the European Union, but across the world. And we can see this, for example, in the Dutch Act on Integration Abroad, which essentially requires non-Western immigrants to sit an integration exam in their country of origin before they then request a provisional residence permit once they're in the Netherlands, which is then in the Dutch context actually not a requirement for Western immigrants. And so we can kind of see that if we see that this non-Western origin is arising as a dividing factor in the Dutch context, but also in the Danish context, we clearly see that this case really has a lot of ramifications beyond just Denmark. And I also consciously use the word reinvigorated because I think this dividing language of Western versus non-Western origin is, in my view, in some way echoing some of this historical rhetorical language that has also been used to racialize and also then harmfully discriminate certain marginalized groups. So I put Western versus non-Western origin in a long line of language, such as concepts such as civilized versus uncivilized, or us versus them. And if we then view the Danish law on public housing case from this angle, I think that we can clearly see that a lot of stakes rest on this question of whether this category of non-Western origin is actually directly or indirectly discriminatory. To go to the first leg of my argument, and I think I'm also kind of building up on maybe something that also Professor Ćapeta also noted and kind of mentioned a little bit earlier just now, is that I think there definitely is sort of like this expectation that the court, at least when it's addressing its equality cases, will hopefully provide some clearer definition of ethnic origin, and also then clarify what are the criteria that can identify an ethnic group. And I also quite note in my own analysis of the court's jurisprudence is that when the court has been interpreting the Race Equality Directive from the onset, it seems to have really placed ethnic origin as a central analytical anchor of the Race Equality Directive. And now, I agree with, I think that it's quite important, of course, to also kind of nudge the court to clarify this important concept of ethnic origin. However, in this presentation, I want to kind of broaden this analysis and also kind of shift the focus as well to another equally important concept, which I think has been quite overlooked by the court, which is that of race. And I want to sort of move and sort of shift that discussion to this concept as well, because I think that the court's fixation on the concept of ethnic origin does to some extent also constrict the court's analysis when it comes to really grasping the nature of racialization and harmful racial discrimination across the EU. And so in my argument, I'm essentially saying that racialization, in my view, accurately captures the various harmful legal practices, such as those that are actually in the Danish law of public housing, where this law is actually constructing and sustaining racial hierarchies across the European Union. So when I'm talking about racialization, what do I mean by that? Racialization or race making is essentially sort of this language is kind of is quite prominent, of course, in sociology, for example, and those types of disciplines, but it's also kind of also making its mark in legal scholarship, whereby there's a growing understanding that race is not some biological idea, but race is more so actually about it's a social construct and a contextual method that can actually be used to distribute resources, benefits, and power. And so in that sense, if we understand race in this way, race is no longer this fixed construction that can be determined by objective or neutral criteria. Rather, race becomes this social construct that produces or crafts some sort of color line that tends to then be intensified by structures of domination such as nationality, religion, and class or socioeconomic criteria. And so you can clearly see that by bringing all of these elements of skin color, nationality, religion, and class, racialization tends to be this intersectional process where different elements work together to essentially synergistically cause some racial harm. And in my view, I would say that if we view the Danish law on public housing from this angle, I would argue that this law is essentially engaging in race making and is also constructing some form of a racial underclass. However, I think that when I read the court's judgment, I don't really see the court approaching this case from this angle. And I think there's multiple reasons for that. For one, I think there's definitely some structural shortcomings in the context of the equality law structure itself, which of course the courts cannot change by itself. But I think, for example, one of those structural shortcomings has to do with the fragmented legislative framework in EU law. If we think about the aspect of nationality, which is so central to this demarcation of non-Western countries in this Danish law on public housing, we can't really address nationality discrimination fully within this context of the Race Equality Directive, primarily because of this nationality exception. The court has, of course, addressed this and then kind of found a workaround for it. However, I still do think that this nationality exception kind of puts this Race Equality Directive on some shaky foundations. If we want to look at it from the angle of religion, and I think religion becomes relevant here in this Danish law on public housing, because it's also something that Advocate General Ćapeta noted in her opinion, that this sort of Western countries group kind of tends to be grouped together because there's this idea that they share similar religious convictions. So this kind of brings a discussion of race into this religion, excuse my apologies, into this case. However, we can't also really address religion entirely, primarily because, of course, religion is only covered when it comes to the Framework Employment Directive, which again is also only for the context of employment. If we then want to discuss the socioeconomic criteria, this could possibly be addressed by Article 21 of the Charter. However, even there, we're also kind of blocked with the reality that this provision, of course, is only applicable when member states are actually implementing EU law, which is not the case here. So, of course, I acknowledge that these are also aspects that the court has to consider in its own analysis. However, I think beyond these structural, more framework shortcomings, I do think that there's also space for some analytical depth that the courts could hopefully also kind of develop within its future cases. I want to start with a little bit of a positive note, which is that I think that the court seemed to show some cognizance of intersectionality in some paragraphs of this case. So, for example, in paragraph 100, when the court is kind of dissecting this concept of non-Western origin, it seems to say, well, this idea of non-Western origin seems to be a complex combination of criteria that are working together to construct this group of people. So we can see that it's something about the country of birth and also the nationality working together to then synergize and come together to create this group of non-Western origin. However, I think that the court then kind of stops short there and doesn't really develop this idea in a more intersectional sense any further, primarily because it reverts back to this, of course, this very important concept of ethnic origin, but one which tends to then really kind of overpower the court's analysis. So because the court is so fixated on ethnic origin, it can't really then bring the equally important socioeconomic criteria, which are actually also very pivotal to really kind of differentiating a certain group that then can face forcible eviction. And of course, that's kind of sort of natural to ethnic origin. It kind of is very difficult to bring discussions of class and socioeconomic criteria into it. However, that's also exactly the reason why I argue that it would have been much more interesting for the court to really approach the racialization that's happening here in the Danish law on public housing. And I think the concept of race and the notion of racialization would have enabled the court to combine both the aspect of these nationalities that are kind of being singled out and how they work together with the religion, but also together with the socioeconomic criteria to really construct some type of racial underclass in Danish society. The second leg of my argument pertains to an argument that a conclusion I would say that the court is maybe alluding to towards more so the end of its judgment, when it's kind of discussing the possibility of indirect discrimination. And in paragraph 151, the court essentially alludes to some point of that the Danish law on public housing could potentially be justifiable when it comes to non-Western third country nationals. And I found that to be quite an interesting conclusion, primarily because in my view, at least, I think non-Western third country nationals are, in my view, equally marginalized as EU citizens or with a non-Western origin. However, I see here that the court seems to kind of leave an opening for this Danish law on public housing to not be justifiable for EU citizens of non-Western origin, but to some extent to be justifiable for non-Western third country nationals. And I think one of the reasons why the court reaches this conclusion and sort of finds it possible and justifiable to maybe kind of render non-Western third country nationals to the mercy of this Danish law on public housing is primarily because the court really kind of relies on this use of comparison and also relies on comparators in general. And in an earlier paper of mine that I published last year, I was kind of deconstructing this reliance on comparators. And I argue there that essentially I think that comparison sometimes has attained this hegemonic, to use Gramscian terms, hegemonic status in EU equality law, whereby we all are so used to relying on comparison and comparators to establish discrimination, that we no longer actually think about whether this comparison that we're doing is actually furthering our analysis and helping our analysis any further. And I kind of start to see the problems with comparison within this Danish law of public housing as well. For example, we see that it's often quite difficult to agree on the appropriate comparator in cases. I think we can see, for example, in Advocate General Ćapeta's opinion, we see that she is quite emphasizing the comparison between Western versus non-Western origin, whereas the court in its judgment uses a host of different comparators, with one being, for example, comparing transformation areas to vulnerable residential areas. And my point here is not that one form of comparison is better than the other, but more so just that to show that it's kind of uncertain which comparison is appropriate in a singular case. The larger point I want to bring here is that sometimes this fixation and comparison can actually lead the court to legitimate and naturalize a very problematic form of discrimination. And we see this in the Danish law on public housing case, when the court is comparing non-Western third country nationals to EU citizens with non-Western origins. And I think the problem that I'm seeing here is that the court, because it's so fixated on conducting a comparison, it kind of loses sight of the need to have a more contextual analysis of the Danish law on public housing itself. Because I think the main point and the main problem, from my view, with the Danish law on public housing is that it essentially tries to present non-Western third country nationals as people who are innately just for some sort of autonomous reason out of their own will, that they then end up usually be struggling to find employment or struggling to gain some type of education and so forth. It kind of presents these socioeconomic criteria as things that are innate to non-Western third country nationals. However, a more contextual analysis of the Danish law on public housing would lead us to the conclusion that it is actually the Danish law on public housing that is actually constructing a racial hierarchy, and then also disproportionately places non-Western third country nationals in a vicious cycle of socioeconomic precarity. Because, of course, one of the risks that emanates from this law is that you could be forcibly evicted. And so you're being uprooted from your community, which then also dashes the opportunities for education and employment and so forth. However, because the court is so embroiled in kind of conducting a proper comparison, it kind of leads to this road where the court then says, well, if this law must be justified, then let's justify it for non-Western third country nationals. But then, of course, because of EU citizenship, we cannot justify it for EU citizens with a non-Western origin. And this then, of course, essentially allows the courts to end up exonerating the law on public housing and not realizing how the law itself is actually constructing a racial hierarchy. And I think the reason why we end in this conclusion is primarily because we're so embroiled in comparison that we lose sight of the reason of the need to actually conduct a more meaningful contextual analysis. So to summarize my main arguments that I've made here, which are twofold, I first said that in my view, direct racial discrimination in this Danish law on public housing, and the gravity of it at least, tends to be obfuscated when EU equality law is reluctant to engage with the concepts of race and racialization. Ethnic origin is, of course, very important and also needs to be enunciated, but I think there is also a role and a space for race and racialization to play. And secondly, I think our fixation sometimes on developing certain equality law doctrines, such as comparators, can make us lose sight of how, if we always kind of use these problematic legal doctrine, we can end up having EU equality law claiming to advance equality, but actually ultimately legitimating inequality instead. That was it from me. Thank you very much.
Thank you very much indeed, Nozizwe, for highlighting some really important technical aspects about EU equality law, as well as some more substantive aspects about the challenge of not directly tackling the issue of race and racialization. So now we're going to turn to Hanna Eklund. Hanna, the floor is yours. Thank you. Oh, if I could just say, please don't forget, everybody, to send in your questions. We are eagerly awaiting those. Thank you, Hanna. Over to you.
Thank you. Thank you very much. Thank you to you, Iyiola, and also to the European Law Review for organizing this seminar. I'm very happy to be here. And as already has been shown, there are many angles that you can choose, I think, here to discuss this case. And I also think that you can start in different eras or in different years, let's say, to explain how we got to where we are today in Europe on the question of equal treatment, irrespective of race and ethnicity. And I will limit myself to making 2 points. The first point is the reason for why I think the legal status of citizenship is important to understand the circumstances of the case and organizing the legal reasoning of the case, specifically the question of direct discrimination. And then also I will make the point that I would agree with the Advocate General's opinion that this indeed is a case of direct discrimination, and it should have been decided as such. So I will start at the point where the court turns to the question of direct discrimination. That is in paragraph 78 to 80. And I would consider this a strong opening. And I would think that here you see the contours of some version of clarification or guidance on how we should understand the criteria of ethnic origin in the directive. So the court starts in the directive, goes into Article 21 of the Charter, through to the European Convention of Human Rights, into the International Convention on the Elimination of All Forms of Racial Discrimination, and says that discrimination based on ethnic origin is a form of racial discrimination. And this is perhaps already there in the case of Chess, but as the case Jyske Finans happened, I think this is an important statement and an important framing. So at this point, I would say we have some form of sort of conceptual clarification. What I then think happens is that the court takes a sort of a suboptimal, I would say, exit through to the term of nationality and into the country of birth. And this is in paragraph 81 to 86. So from this contested category of immigrants from non-Western countries and their descendants, the court is deriving nationality and country of birth to assess whether the category, the contested category, is based on an ethnic criterion. And the Danish government states that this is a complex combination of criteria, and the court appears to agree. But I would suggest that the fact that 9 or 10 out of the 11 litigants are Danish citizens, and that immigrants from non-Western countries and their descendants is a category with the function of identifying Danish citizens of non-Western origin clarifies the combination of criteria. If you say people are from different countries, or people are born in different countries, nationality and country of birth are, as the court says in paragraph 99, you could say there are neutral criteria. But if you say within the category of Danish nationals, Danish citizens, we distinguish your country of origin through your own place of birth or that of your parents, the function is to identify a subgroup within the citizenry. And that subgroup is based on descent, categorized as non-Western. Western is Europe. We've already heard about this. Western is Europe. The so-called white dominions and the United States is sort of a geographic constellation of white, culturally Christian population of, let's say, European ethnicity. So non-Western ethnicity only exists as a description of what is not included in the Danish idea of that which is Western. And I will here now turn to my one and only slide. I hope you can see it here. So this, what you're looking at, is a screenshot of an Excel sheet that I got from the Danish Statistical Agency. And it's the Danish Statistical Agency provides the categories, the definitions that is used in the contested law on public housing. And I have kept this like a screenshot of an Excel sheet without translating it, because to me this is an artifact of where we are in Europe in terms of citizenship and in terms of the debate that we're having right now. So I just want to introduce this to you by saying that I emailed the Danish Statistical Agency and I asked how many Danish citizens are categorized as non-Western, and within 30 minutes I got this Excel sheet. So it's a very well organized state agency. So at the top, you have citizenship, and this is the whole Danish population. So you have the whole of Danish citizenships, Western citizenships, non-Western citizenships, and then the total. So if you're looking at the screen on your left side, you have the origin of the population. And it says origin/country of origin. And so you have people with Danish origin, and then they subdivide. So you have immigrants, Western origin, non-Western origin, descendants, Western origin, non-Western origin, and this is for 2024 and 2025. So if Denmark want to take the group of non-Western nationals, and this Nozizwe have already been laying this out for us, so what in EU language is called third country nationals. And if they want to take this group and decide where they can live for integration purposes, this would have been a different case. It's not the case we have. We have a case, we have legislation, we have based on a statistical system that wants to distinguish within the citizenry. To distinguish based on citizenship is not enough. And this is also described in the preparatory works that the court cites that repeatedly refers to the idea of the ethnic composition of the citizenry. And I will now close this so I come back to you. The court says, as we have already heard, that it will not take a decision on the question on whether or not the criterion of immigrants from non-Western countries and their descendants is based on an ethnic criteria, but it instructs the national court to keep 4 things in mind. First of all, it does not have to be a single ethnic group that is being singled out for discrimination, let's say, for it to be discrimination. This is a welcome clarification after the case Jyske Finans. The second thing the National Court should keep in mind is the context. It should read the preparatory works. Here, I would have preferred that the court again cites from the preparatory works because they're very, very telling. But that is perhaps a matter of taste. The third thing the National Court should keep in mind is the fact that people categorized differently by the Danish state were affected does not preclude discrimination. Okay, that is fine. And then the fourth thing, and here we return to our complex criteria. Again, the court says it can still be discrimination even if immigrants from non-Western countries and their descendants appears to include people of Western origin. Still, there would be a different way of, maybe even a reversed way of placing the emphasis here, highlighting that the function is to distinguish within those with Danish citizenship based on their descent. That is the actual effect of the statistics, and that is the stated desired effect of the statistics. And this is somewhat lost. But to broaden the perspective, I think that we might be re-entering an era, a moment, say, in which citizenship and nationality again, and Nozizwe has already mentioned the kind of long perspective that I think it's important that we have, again acquire different meanings. Nationality is citizenship plus national ethnicity. Citizenship becomes stratified or scaled based on ethnicity and race. I have done research on colonial citizenship law, and the most striking thing to me as a researcher about this case is how this Excel sheet plus the law on public housing is so similar to such colonial legislation. The most striking thing to me as a Scandinavian, I am Swedish, but I work in Copenhagen, is that Scandinavian democracy fails to secure equality before the law in this era that we are in. But I want to end by noting the same paragraph that Nozizwe already pointed us to, namely 151. Because the court says discrimination, it might be direct discrimination, and then it moves to assess indirect discrimination. I want to say that I think that in no way, shape, or form is there anything about this case that is indirect. Not the preparatory works, not the legislation and not the statistical resource used to construct the law in question. But when the court has gone through whether or not this could perhaps be on the way in which it could be indirect discrimination, and it arrives at the question of objective justification, the national court has stated this is social cohesion and integration. This is our objectives. The court says, for the first time, it brings in the concept of citizenship. And it says, in essence, you cannot integrate your own citizens. You cannot justify evicting your own citizens based on the objective of integration. This is something to work with, because that goes counter to what the Danish government is trying to do, and I think what many other governments are trying to do when they're trying to distinguish between citizenship. What it is also doing, as Nozizwe is pointing out, it is of course creating an even sharper boundary between third country nationals and EU citizens. This is true, and this is problematic in and of itself. But what we're dealing with here is the fragmentation from within of the very construct of citizenship. And here the court is putting some form of version of a boundary by saying, no, you cannot integrate your own citizens. And perhaps in the margin of everything that we're living through, that is somewhat helpful. So I will end there. Thank you.
Thank you very much, Hanna. Really interesting to have you bring out there the similarities with colonial citizenship and the general fragmentation by the court, which is a really interesting and worrying aspect as well. So finally, thank you for waiting very patiently, Bruno. I'll turn the floor over to you. Thank you.
Thank you, Iyiola, and good evening, everybody. Iyiola introduced me by saying that I would talk about the institutional dimension or perspective of the case. But I will take a very narrow one, a very narrow institutional perspective, which is to look at the functioning of the preliminary ruling mechanism in this case. Now, we know that occasionally national courts make life difficult for the Court of Justice by sending in one case, lots of different questions, not well explained. So it's a bit of a mess. And then the Court of Justice would typically say, what the national court in essence wants to know is this and that. So they reformulate the questions. We know that. Now, in this case, there was absolutely no need for that, because the Danish court asked two simple questions. The first one was about this notion of ethnic origin, which has already been discussed. And the second one was quite simply, must the Race Equality Directive be interpreted as meaning that this legislative scheme in Denmark, the Public Housing Act, constitutes direct or indirect discrimination? That's it. Very simple question. And so, logically speaking, there were three possible answers to that question. There is no discrimination, or there is direct discrimination, or there is indirect discrimination in the law. Mind you that the question was not about what the actual facts, the implementation. The question was about the scheme, the legislative scheme. Now, the court then engages in this lengthy analysis of whether there is direct discrimination and concludes basically that there is, for the reasons which have already been explained by the other speakers. It's quite clear here. There is direct discrimination because people who live in so-called transformation areas are being treated less favorably than people living in so-called vulnerable areas. And the difference is that in the first category, you find a certain percentage of people of non-Western origin. So there's a clear disparate treatment which has negative consequences for these people. So the judgment could have ended here. Instead, surprise, the court spends another 50 paragraphs on whether the Danish legislation constitutes indirect discrimination. And the general conclusion of the court is then that the legislation can be either direct or indirect discrimination, depending on how you look at it. Whether you look at the text of the legislation itself or on how it's being applied in practice. Now, that's, I think, a very unhelpful answer to the Danish court, because the court had asked, is the scheme, the legislation, is it direct or indirect discrimination? The court doesn't clearly answer that. And by doing so, it also considerably muddles the crucial distinction between direct and indirect discrimination in this piece of legislation. Because the thing to remember is that this directive, the Race Equality Directive, is based on a crucial distinction between direct and indirect discrimination. In contrast, let's say, with the European Convention of Human Rights, or even the general principle of equality in EU law, where even distinctive treatment can be justified. Both distinctive treatment and formal equal treatment can be justified. Not so in the Race Equality Directive. The only justification for direct discrimination is when it's about a genuine and determining occupational requirement. So in the context of employment. We're not in the context of employment here. We're in the context of housing services. So there is no justification possible for direct discrimination. Whereas indirect discrimination under this directive can be objectively justified by a legitimate aim. So the whole discourse of the court about integration and social cohesion as possible legitimate aims is relevant only, would be relevant only if the Danish legislation were neutral on its face and therefore only indirectly discriminatory. But it's not. It's legislation that treats persons differently and less favorably on grounds of their ethnic origin, and therefore there's no room for justification. So the Court of Justice can do two things in preliminary rulings. It can sort of write complete chapters of a textbook of EU law and send it to the national court. And that's what the court did very much here. A whole textbook chapter on equality law. Or alternatively, the court can give a useful answer to the referring court. And so my criticism of the judgment is not so much what it said about direct discrimination, where I basically agreed. My criticism is that the Court of Justice failed to give a useful answer to the question asked by the Danish court, which is this direct or indirect discrimination? There's a clear answer to that. And the court should have stopped there, and leave its reflections on indirect discrimination for another case. Thanks a lot.